Hi, this is Sleeping Giant Awake with part 1 of my 3-part series, Gay Marriage in Utah. This is called How We Got There. On December 20th, 2013, Judge Robert Shelby in the U.S. District Court for Utah ruled in favor of the plaintiffs in Kitchen v. Herbert. This decision immediately made same-sex marriage legal in Utah. The first marriage license was issued to Michael Ferguson and Seth Anderson in the early afternoon, and they became the first same-sex couple to be married in Utah. Many more marriage licenses were issued that week. To understand the significance of this, we must know the context. The history of same-sex relationships, unions, and marriages stem back to the earliest corners of history, and it has persisted ever since. It is found in all cultures and ethnicities. Homosexual behavior is exhibited by other mammalian creatures that have been studied for it. Despite these facts, homosexuality is treated by many in modern American society as freakish and undesirable. People who are attracted to others of the same sex are bullied and treated as second-rate citizens. Some even are physically beaten to the point of death. Some of these bullies are willing to admit that they don't believe that their victims have a choice in the matter and choose to bully anyways. But there are those who, because of their dogmatic upbringing and misinformed opinions, who actually believe that homosexual persons choose their sexual preference and that they could pray their gay away if they only put forth the effort. In short, the issue of homosexuality is approached with fear, misunderstanding, and even hatred in this country. Now to the legality of the issue. In 1970, in Minnesota, 2 men applied for a marriage license, but were refused because they were both men, even though the state law didn't specify that aspect. Had they not been refused, they would have been the first same-sex couple to be married in modern times. At this time, homosexuality was at very least frowned upon, and homosexual people were targets of hate crimes. The men appealed to the state Supreme Court, which said that their constitutional rights were not violated, and the National Supreme Court refused the case for want of a substantial federal question. On January 1st, 1973, Maryland became the first state in the United States of America to statutorily ban same-sex marriage. Nearly every state in the country would follow suit over the next 20 years, as this became the legal status quo in the country. In the meantime, in this country, more homosexual people identified themselves openly as such, and the nation as a whole became more accepting of our homosexual brothers, sisters, sons, daughters, neighbors, and friends. Despite this, we as a nation were not willing to accept same-sex couples as equal to heterosexual couples. Then in December 1990, 3 same-sex couples in Hawaii applied for marriage licenses. After being denied, they started the legal process. Bear versus Mike became the final name of the trial that proceeded. The court created a commission to research and study the harmful risks and the benefits of same-sex relationships and to form an opinion for the court as to whether to extend marriage benefits to same-sex couples. In December of 1995, they issued their report, favorable to extending marriage to same-sex couples. In December 1996, the judge ruled that the state had not made a compelling argument against extending marriage to same-sex couples and overruled the statute that was in place. The next day, he stated his decision is legally untenable if the Supreme Court overturned his decision. On a national scale, in the spring of 1996, the Defense of Marriage Act, or more commonly called DOMA, was introduced into the House of Representatives and the Senate by the GOP. Even though it flew through both with a strong majority, it was still harshly criticized. Colorado Republican Patricia Schroeder said, "You can't amend the Constitution with a statute. Everybody knows that. This is just stirring the political waters and seeing what hate you can unleash." And Senator Ted Kennedy said that it was a mean-spirited form of legislative gay bashing designed to inflame the public 4 months before the November election. Bob Barr, who introduced the bill, would later apologize and call for its repeal. On September 21st, 1996, President Bill Clinton signed DOMA into law. At the time, he was against same-sex marriage, but thought that such a law was unnecessary. He later changed his opinion in favor of same-sex marriage and urged the Supreme Court that DOMA be overturned. In 1999, Vermont's Supreme Court found that denying same-sex couples the same rights as other married couples was against their state constitution. In 2000, Governor Howard Dean signed a bill into effect giving same-sex couples access to the same rights of married couples. Then in 2003, in Massachusetts, the state Supreme Court ordered the state to either legislate law giving same-sex couples access to the same rights as married couples within 180 days, or same-sex couples would be able to marry. New Jersey and Maine both adopted partnership bills in early 2004. In mid-2004, due to the Massachusetts legislature not taking action, they became the first state to legalize same-sex marriage. In 2006, New Jersey legalized same-sex civil unions. In 2007, Washington, Oregon, and New Hampshire adopted domestic partner and civil union bills. On August 30th, an Iowa court strikes down a same-sex marriage ban. This immediately resulted in the legalization of same-sex marriage in the state. About 20 marriage certificates were issued before the ruling was stayed. In 2008, Supreme Court of California legalized same-sex marriage. In October, the Supreme Court of Connecticut also legalized same-sex marriage. Then in November, by a small margin, Proposition 8 passed in California, creating a new ban of same-sex marriage there, but the marriages that had already been performed would stand as legal. This is fairly controversial here in Utah, as there were strong reasons to believe that the Church of Jesus Christ of Latter-day Saints leadership had funding directed to support Proposition 8. In 2009, the Supreme Court in Iowa legalized same-sex marriage. In Vermont, same-sex marriage was legalized for the first time in our country's history through legislation being introduced in the state Senate and House and voted into law. On May 26th, the Supreme Court of California upholds Prop 8. Also in 2009, Nevada voted in a domestic partnership bill. New Hampshire legalized gay marriage, and the District of Columbia passed a bill into law legalizing same-sex marriage. In 2011, Illinois signed a civil union bill into law. In June, New York legalized same-sex marriage through legislation. In early 2012, both Washington and Maryland legalized same-sex marriage, but opponents countered with a referendum, and in both states, and also in the state of Maine, voters democratically approved same-sex marriage. In Minnesota, voters rejected an amendment that would allow same-sex couples to marry. And in early 2013, Colorado signed a civil union bill into place. In Delaware, same-sex marriage was legalized through legislation. In mid-2013, probably the most important decision made so far in the United States regarding same-sex law, the Supreme Court of the United States of America ruled that California's Proposition 8 and Section 3 of DOMA are unconstitutional. Later, 2013, Hawaii and Illinois legislate same-sex marriage into law. Also, the Supreme Court of New Mexico legalized same-sex marriage on December 19th. Then, on December 20th, to the complete surprise to everyone in Utah, the state in which I live, same-sex marriage suddenly became legal. It became legal through a decision made by Judge Shelby. I had only loosely followed this issue in the federal arena, in which I saw blue states slowly realize that our lesbian and gay sisters and brothers deserve equal marriage rights. These are the same rights to which I, as a heterosexual, could so easily take for granted. These decent human beings, because they wanted to share their love and their lives with a partner of the same sex, were treated as lesser than, and for something they couldn't choose. Personally, I was caught off guard when I discovered that gay marriage was legalized in Utah. Living here, I am familiar with the dogma that directs the conscience of the state. It took me a couple of days to realize that legal same-sex marriages were actually going on. I knew that the state would do what it would take to have a stay put in place. But the way that it came about is what drew me into this story. The more I learned about it, the more I realized just how significant this case is. I read the full decision by Judge Shelby, and when I understood his reasoning, I realized that we're on the verge of a big change. That's why I wanted to make these videos. I feel that it's important that the information regarding his decision and the potential implications are available to anyone who is interested. So I'll let the Honorable Judge take it from here. Judge Shelby in his written judgment said this: "The court agrees with Utah that regulation of marriage has traditionally been the province of states and remains so today. But any regulation adopted by a state, whether it be marriage or any other interest, must comply with the Constitution of the United States. The issue the court must address in this case is therefore not who should define marriage, but the narrow question of whether Utah's current definition of marriage is permissible under the United States Constitution. It is only under exceptional circumstances that a court interferes with such action. But the legal issues presented in this lawsuit do not depend on whether Utah's laws were the result of legislation or a referendum, or whether the laws passed by the widest or smallest of margins. The question presented here depends instead on the Constitution itself, and on the interpretation of that document contained in binding precedent from the Supreme Court and the 10th Circuit Court of Appeals. Applying the law as it is required to do, the court holds that Utah's prohibition on same-sex marriage conflicts with the United States Constitution's guarantees of equal protection and due process under law. The state's current laws deny its gay and lesbian citizens their fundamental right to marry, and in doing so, demean the dignity of these same-sex couples for no rational reason. Accordingly, the court finds that these laws are unconstitutional. All right, so what does all this mean, and what should we expect? For those answers and to see his decision in more depth, look forward to part 2. And a link to Judge Shelby's decision is in the description, as well as the other sources I used to compile this video. Thank you for your views and your considerations. I'm out.